as it is. Okay, well, welcome to this morning's session of the Kansas Court of Appeals. I'm Karen Arnoldberger. I'm the Chief Judge with the court, and I'll be presiding today, which simply means I'll be attempting to keep time. To my right is Judge Henry Green. Judge Green hails from Leavenworth, Kansas, and from my calculations this morning has been on our court for 28 years. He is the longest serving judge on the Kansas Court of Appeals. On my left is Judge Michael B. Boozer, and he has been on our court for 16 years. So I'm the baby of the group with only 11 years, but we have a lot of experience here, and hopefully we can help figure this case out. With that, you each know that you have 15 minutes to argue. Since this is on YouTube, I will allow the appellant about 2 minutes at the beginning just to do a brief overview of the facts of the case, just so somebody watching this will kind of know what the case is about, and I won't count that against your time. With that, would the parties please state their appearances in case number 123360, Sacred Leaf LLC and Trevor Burdett versus Cyrus Riahi.
Thank you. Sacred Leaf LLC and Trevor Burdett, the appellants, appear through counsel Matthew Donnelly.
Okay, thank you.
And the appellee, who is the defendant in the underlying case, Cyrus Riahi, appears through counsel me, Eric Carter.
Okay, thank you. With that, we will go ahead and get started. I want you to know that I think all three of us have multiple monitors we're looking at. So if we're not looking at you at the moment you're arguing, it's simply because we're looking at our monitors where we have your briefs, and because we are just high tech now, which this is about as high tech as it gets for us. So with that, let me get my little timer started here. And I am ready. Mr. Donnelly, you can proceed.
Thank you very much. So this is a case.
Oh, I'm sorry, Mr. Donnelly. I needed to ask, did you want to reserve any time for rebuttal?
I would go ahead and reserve 5 minutes for rebuttal.
5 minutes. Okay. I'll let you know if you start pushing into that time. Okay.
Thank you.
Go ahead.
So this is a case about a settlement agreement that was negotiated between two businessmen to settle a prior dispute, a prior lawsuit. It's undisputed that one party, Mr. Burdett, who I will collectively refer to the appellants today as Mr. Burdett, it's undisputed that Mr. Burdett performed each and every obligation that he had under the settlement agreement that was negotiated between him and Mr. Riahi. It is also undisputed that Mr. Riahi did not. Mr. Riahi's breach of the settlement agreement, I believe the evidence shows, was intentional and therefore should not be rewarded. The posture of this case from the district court was that the district court found that Mr. Riahi had not materially breached the settlement agreement, and there was also an attorney's fees provision in the settlement agreement. So in the end, the district court awarded Mr. Riahi attorney's fees. And our position is that, again, Mr. Riahi should not be rewarded for his intentional breach of the settlement agreement and refusal to attempt in good faith to perform under the settlement agreement. So the first point that I would like to make was that, contrary to what the district court found, there was not substantial performance. In this matter, the facts I don't believe are in dispute. I don't believe that there's any material facts regarding the performance under the settlement agreement that are in dispute. And therefore, the court may determine whether a party has substantially performed as a matter of law. So it's undisputed that there was this contract, this settlement agreement. It's undisputed there was sufficient consideration. Mr. Burdett paid $45,000 in exchange for certain promises by Mr. Riahi and in exchange for his membership interest in Sacred Leaf LLC. There's no dispute, and in fact, Mr. Riahi testified that Mr. Burdett performed all of his obligations under the settlement agreement, and that Mr. Riahi failed to perform as specified in the contract. Under the Dexter case that I believe Mr. Riahi had cited and the district court had as well, in order to find the defense of substantial performance, there has to be a good faith attempt to comply with terms of the agreement. And what Mr. Riahi did was not in good faith. So substantial performance cannot exist if the breach is willful or deliberate. So the settlement agreement required that after 3 months from the signing of it, that a certain sign had to be delivered. It was signed, the settlement agreement was executed on March 26, 2019, making the delivery due on June 26, 2019.
Was it a particular sign that was supposed to be delivered or just a sign? One of the 3 signs?
It was one of the 3 signs.
Okay, so your client had no guarantee as to which sign that would be.
That's correct.
Okay.
But the 3 signs were all similar. They were all signs that you could put lights in that would light up that you could put on a storefront.
Right.
So a couple days after the time for performance, June 26th, Mr. Riahi's counsel was contacted with the information that your client didn't meet this deadline. When settlement was negotiated there, that didn't occur. Eventually, several days later, Mr. Burdett directly contacted Mr. Riahi, and this goes to the breach being willful or deliberate. Mr. Burdett asked Mr. Riahi if he was planning to comply and informed him that he was in breach because he didn't deliver the sign by the specified date. And Mr. Riahi belittled Mr. Burdett, used some pejoratives, told Mr. Burdett that he was not going to comply with the settlement agreement, and told him that it was worth his money if he got to talk to Mr. Burdett's wholesalers, which Mr. Riahi later testified at trial meant that he didn't like Mr. Burdett. So if the disparagement clause in the settlement agreement was somehow void, then he would have been able to talk to Mr. Burdett's business affiliates in order to interfere with his business. In this text exchange, Mr. Riahi never offered to perform. Several more weeks go by, and I guess I'd back up. In fact, Mr. Riahi directly told Mr. Burdett that he wasn't going to honor the contract and that Mr. Burdett would have to sue him. Now, in his testimony at the trial, Mr. Riahi walked that back and said when he told Mr. Burdett, "So sue me," that he didn't really mean it. Given the relations with these parties and that they had just gone through a lawsuit, and this was regarding a settlement agreement from a prior lawsuit, I do not think that's a reasonable interpretation for Mr. Burdett to take when he says, "I'm not going to comply, sue me." So several weeks later, on July 23rd, when Mr. Riahi had still not attempted delivery of the sign, Mr. Burdett filed a lawsuit in the Johnson County District Court alleging breach of contract. And so the point is, what Mr. Riahi did is deliberate conduct. He specifically knew that he was in breach. He told Mr. Burdett he was not going to perform. He told Mr. Burdett essentially that he was going to have to sue him to gain the benefit of the bargain that they had just negotiated. This was the first thing in the settlement agreement that Mr. Riahi had to perform, the very first. And when he did eventually, there's some evidence that Mr. Riahi did eventually attempt to perform on, by the way, the exact same day that the lawsuit was filed. But when he did attempt that, what happened was he sent someone who Mr. Riahi couldn't quite remember his name.
Let me interrupt for just a second. Is it undisputed that he made an attempt to deliver the two signs to the wrong address on the day the lawsuit was filed?
No, Your Honor. I believe
there's no dispute. Okay, that's all I wanted to know.
Well, no, and if I could, I believe it's undisputed that he made an attempt to deliver one sign to the wrong address.
Okay. Right.
Now, Mr. Riahi, again, this goes to the unreasonableness of his attempted performance, but Mr. Riahi did not have, he didn't inform Mr. Burdett that he was going to be delivering the sign to this location. Mr. Burdett had provided him the correct location to deliver the sign to weeks prior. So, you know, this again was not a reasonable attempt at performance. The location in Lawrence where he attempted delivery had no idea that he was showing up. They didn't have the capacity to store this sign. And so, in short, it just was not a reasonable attempt at performance. So it was not a good faith attempt to comply with the terms of the settlement agreement. So we believe that it was error for the district court to afford Mr. Riahi the defense of substantial performance under the facts of the case. So if substantial performance is not available to him, we believe that the court should have found that there was a material breach of the settlement agreement. But the trial court essentially wanted to ignore virtually everything in paragraph 2, small Roman numeral 6, which is the paragraph in the settlement agreement about the delivery of the signs and when that should occur. The trial court essentially said there is no material breach unless each and every sign was not delivered by the last date provided. So it was to be staggered 3 months, 6 months, 9 months. The district court essentially said that there's no breach, there's no material breach unless each and every provision in there is breached, which I think that interpretation simply cannot be the law of Kansas. The trial court wants to rewrite this agreement, but certainly, and I pointed in the brief to the First National Bank case that I think is analogous. That case involved a loan for a commercial real estate project.
If you don't mind, let me interrupt you for a second because you're about out of your initial time.
Sure.
And let me get to the issue of the liquidated damages provision. Let's assume for a minute that there was a material breach. But I would like you to address whether this paragraph was a penalty provision or a legitimate liquidated damages provision, because generally liquidated damages provisions, the way I understand it, are used when the amount of the damages is hard to ascertain. Here, I think all parties agreed that $10,000 was the value of all 3 signs in the canopy, that's why $10,000 was put in there. So would you address that, please, in your remaining minute, I think, before your initial time is up?
Sure, thank you. Well, the liquidated damages provision, first off, needs to be viewed prospectively. And I think that we're now viewing it after the fact, but the fact is that there was also delay damages. And the delay
There were
damages,
what? I'm sorry, I didn't hear you. Could you get closer to your microphone or
there's
something?
also delay damages. And so there was some testimony that the value of the signs was about $10,000 roughly. But I don't know that there was testimony regarding that being the specific reason for arriving at that number. So this was a settlement agreement. Public policy favors honoring the terms of that agreement. And, there was some issue with the delay. And again, if that caused Mr. Burdett to delay the opening of his other store in Texas, as there was some testimony.
Okay, you're out of your initial time now. You can address this when you come back.
Okay.
In rebuttal. Okay, Mr. Carter.
You may please the court. This is a very unfortunate case, as they probably all are that come before you. You had invited the appellant's counsel to give a summary of the case, and I at the beginning, and I think you could probably do it very succinctly and just say this was a business divorce, and it was every bit as acrimonious as some bad divorces occasionally are. It's a breach of contract case, so you look at the contract to get a gist of what's going on, and the contract basically. There's obviously lots of provisions and smaller provisions, but what it's really about is the plaintiff, Mr. Burdett, was going to pay $45,000, and the defendant, the appellee, was going to no longer be able to use the Sacred Leaf name, including the signs, and give up and transfer half of the ownership of the company. That's what the essential purpose of this of the contract was. The settlement agreement. It was a business divorce. They were going their separate ways. One person got some cash. The other one got the trademarks, the name, the right to use the name exclusively. So that's what the case was about. It wasn't about the nuances of delivery schedules and that sort of thing. It was about how, he had 9 months to wrap up using the signs. That's it. So there are 3 sections of the settlement agreement that are issued in this case. The first is one is the last section, section 19, which is the prevailing party's attorney's fees. The second one that we'll probably spend most of our time talking about is section 2, taken as a whole. So not just section 2 sub Romanet 6, which talks about the sign deliveries. You need to look at section 2 as a whole to really understand that the essential purpose of the contract was to focusing on Mr. Riahi was going to no longer own 50% of the company, and he was no longer going to have the right to use the Sacred Leaf names, including on the signs. That's what the gist of that case is. So when you look at section 2, sub Romanet 1, the first subsection, Mr. Riahi is transferring his interest in the trademark application. He's transferring his membership interest in the LLC, Sacred Leaf LLC. He's transferring his interest in the logo and trade dress and other brand and trade identifications, that Sacred Leaf name. He's transferring the sacredleaf.com website and different kinds of websites and domains like that. He's transferring the email accounts that go with those. And then the sixth, he's transferring the signs that have that Sacred Leaf name. And you look at that context, you realize that's what this is about. It's not about, Mr. Burdett really needed those signs on those 3 dates. He didn't need the signs. In fact, they're still sitting in his warehouse as of the day of trial. He just wanted them down. He wanted the defendant, Mr. Riahi, to stop using the names. That was the essential purpose of the contract. And it was completed, and it was completed early. And Mr. Burdett had the license to use that name Mr. Riahi had a license to use the trademark name as evidenced on those signs for 9 months. One sign coming back at 3 months, the other sign coming back at 6 months, and then the last at the end of the 9 months. He gave them all back early. And that's, but he had that license, and that's what that was about. I'm sorry.
Counsel, I've got just a factual question.
Yeah.
one sign was supposed to be delivered within 3 months. And am I correct? It was not delivered within 3 months.
That's correct.
But it was delivered a little over 4 months from the date of the settlement agreement?
That's about correct, yes.
Okay. And am I correct that it was only delivered after there was a lawsuit filed for a breach of contract?
The current lawsuit, correct. There had been back and forth negotiations, and they could have been delivered, and he'd offered to have them delivered as of the date that the lawsuit was filed. Unfortunately, what was happening is that I can cite chapter and verse if you need to, but essentially what was happening is that Mr. Burdett was demanding that as part of these discussions that Mr. Riahi pay $10,000 for being late, that $10,000 what I think is a penalty clause, and also pay $2,000 in attorney's fees. And that's the problem with these clauses, not to go kind of into the sort of philosophical thing. The problem with clauses like that, a penalty clause, is it lets one party think that they've got way too much power, way too much leverage, and they demand things that they're not entitled to. Mr. Burdett believed that he was entitled to a $10,000 penalty check. He also believed he was entitled to $2,000 in attorney's fees, and he wasn't. But he wasn't willing to walk away from this thing and just take the signs and be done. He wanted money. He wanted that penalty, because again, this is a business divorce with all that energy.
Was there any allegation or proof of actual damages in this case for the delay in delivering the sign?
So at the very kind of end of the case leading up to trial, for the first time in the pretrial order, the plaintiff made reference to a sign down in Midland, Texas, and he said basically he had, because my client failed to deliver the first sign on June 26, that Mr. Burdett claims that he was forced to go buy the sign and have a sign made for the new store he was opening down in Midland, Texas. And the judge heard that evidence and considered a few factors. But the one that probably was the nail in the coffin and just caused it to just not be credible is that this sign down in Midland, Texas, that Mr. Burdett said he had to order because my client didn't deliver that first sign on June 26. That sign down in Midland, Texas was actually ordered and partially paid for a month before in May, right? So unless he had a crystal ball, how would he know that sign wasn't going to be delivered? In reality, he didn't want, Mr. Burdett obviously, and the substantial evidence would support the judge's conclusion that Mr. Burdett didn't want a used sign, a different sign that was used from the Shawnee, Kansas store that had to get shipped down to Midland. He wanted a new sign. It's a different sign, and that's what he ordered a month before.
Okay, excuse me, Mr. Carter. So are you saying that the decision as to whether or not he'd established damages in this case was really a credibility decision?
Yes.
That the judge made, a factual decision of credibility, and he didn't believe that the plaintiff really was depending on this sign in order to open that Midland store and not have the money he incurred.
Absolutely, that's the case. And again, the fact that he'd ordered the sign a month before it was supposed to be delivered was probably pretty damning. And yeah, frankly, we've all done this law thing for a while. You know that once a party loses their credibility, they're in trouble. It's hard to get it back. So that may be one of the things that was the lens that the judge was viewing through. But the judge is there at trial and is able to see the witnesses and decide who was more credible. I'll continue on.
Yes.
So there was a third section in the settlement agreement that I want to talk about, and it's the section that doesn't exist. It's the section that's in most contracts, and it's the section that normally would read something like, time is of the essence in the performance of this agreement, or something like that, right? It wasn't there. Now, obviously, this is a pretty short and casual document. The settlement agreement wasn't terribly robust, but time wasn't really of the essence. It was missing, and that's pretty good for pretty good reasons, because it didn't really matter to the parties, including to the plaintiff, when any of these signs or any which one of these signs was delivered in any order or at all. What really mattered was that the signs were taken down. That Mr. Riahi stopped using the signs, and they were taken down. There's just now that the smaller detail of when they got delivered. The uncontroverted testimony at trial, and this was touched upon already, was that the canopy and all three signs taken together, their value is only about $10,000. So when you read in the settlement agreement there, it says that in the event Riahi fails to comply with that, subsection 6, that he would have to pay as liquidated damages to Burdett in the amount of $10,000, and Burdett shall additionally be entitled to an injunction to enforce Riahi's compliance with this paragraph. So you see what it's really focusing on then is that Riahi is ceasing to use all 4 of the signs, the canopy and the 3 signs. He's ceasing to use all of them by the end of that 9-month period. It's not about the timing of delivering any one of them. And the focal point, of that, and like I said, it kind of allowed, I think, this plaintiff, unfortunately, to make that unreasonable demand that he wanted the $10,000 penalty because he thought that that's what he had. And in a business divorce, that probably gave a little bit too much energy around taking a hard position. And that's why we have these lawsuits, because people dig in on things that they shouldn't have. There's a lot of chat about the text exchange, but the July 9 text exchange that is probably the most frustrating to look at is when the plaintiff or appellant texted the defendant appellee and just they're going back and forth. The defendant, Mr. Riahi, said, "Okay, well, listen, all of our products and social media maps have been changed, so changing over completely is not a big deal. We were trying to get it done in 6 months from the signing to expedite the process. So we were only down to the signage above the door," right? And the plaintiff responds, "Or to save everyone the time, drop the signs," meaning take the signs down, drop the signs, pay my attorney's fees I have accrued since this, and the 10K. Otherwise, more attorney's fees will accrue and it'll be higher. So this case shouldn't have happened, but it did, and then the attorney's fees grow and people get dug in, and that's why we're here. I think plaintiff felt that he had the defendant by the throat. Unfortunately, he believed he had this unenforceable liquidated damages provision and he could recover his attorney's fees, and that's why we're here. So I think we've talked a little bit about the signs. I happily can talk about that more, but again, this is a case that the essential purpose, as testified to at trial by the plaintiff, as found by the trial judge, was not to make a specific sign delivered on a specific date. The essential purpose of the contract was Mr. Riahi was selling half of his ownership in the business for $45,000, and he was not going to be able to continue using the Sacred Leaf name on signs, with advertising materials, websites, anything. And he had 9 months to be done getting those signs down. That was the essential purpose. I don't know how I'm doing on time, by the way.
You've got a couple more minutes, but we don't penalize you if you feel you've made your arguments.
That sounded a little bit like an invitation to wrap it up.
No, go ahead. You've got 2 more minutes. Please go ahead. I didn't mean it any.
Oh, no. I think just addressing one point, you'd asked a question earlier that it wasn't a particular sign, and first of all, the signs were different. And you're correct that the sign that Mr. Burdett said he wanted to have down in Texas, it didn't look like any one of the three signs that were up. And which of the signs was the first sign that was supposed to be delivered was not specified. And again, the signs were different. And I just can't say this enough. They're all sitting in Mr. Burdett's warehouse up here in Kansas. He wasn't actually planning on using the signs. He just wanted them taken down, which is what happened. I think, of course, I'll be thinking about this later, but eight more points I should have made. Unless anybody has any additional questions, I can wrap it up, and I appreciate it.
The panel have any questions, Mr. Carter? Okay. Thank you. Mr. Donnelly, you have 5 minutes. You're on mute. Our day wouldn't be complete if we didn't have to say that at least once.
Start it off for you guys. As of the date of the trial, which was over a year ago, there was testimony that the signs were still in Mr. Burdett's warehouse. That's correct. I don't know particularly where they are now, but the reason they were in his warehouse is because he didn't get that first sign at least timely delivered. He submitted uncontroverted testimony that he would have used that sign in the Midland, Texas store. Yes, the signs were slightly different, but he testified that this was the type of sign that he could have mounted on that business and that he would have used it.
And do you agree that basically by the judge's decision, the judge made a credibility determination and didn't believe him? Didn't believe that he had intended to use that in Texas?
No, and I don't think the judge said that in his ruling. I think the judge's ruling was based on the fact that he found that the evidence of damages were not specific enough. But the evidence of damages don't have to be exact. Both Mr. Riahi and Mr. Burdett testified about their experience with purchasing these kinds of signs, what the usual cost is for these kind of signs. And they were both pretty consistent. I think the testimony was that the sign that should have been delivered on time was about $3,000. Mr. Burdett testified that as a result of not having that sign, that his business partner went down to Midland, Texas around July 15th and had to reach out to Lone Star Sign Company, the company they'd contracted with, to rush and have them manufacture a sign, which resulted in additional cost to them. So
was there evidence that it was a rush job?
Mr. Burdett testified to that, and I think given the time frame, the ultimate invoice was dated July 25th. Mr. Burdett testified that once July 15th hit, that they had to get in touch with Lone Star Signs and say, hey, we don't have this sign. We're going to have you guys manufacture a sign. The reason part of that invoice was paid previously was there was other work included, like removing some of the things from the prior business that was in that space. Mr. Burdett testified about that, and he said, yeah, Mr. Riahi shouldn't have to pay for those. We were going to pay for those anyway.
Okay. So let's go back to my question from your first go around, and that is, let's talk about the liquidated damages provision, why that is not a penalty provision or an unenforceable liquidated damages provision.
Right. And I know that there was some testimony about this, but I think there is some law that first off honors giving the term what the parties call it in the agreement. And obviously, this was a negotiation. Both parties were represented. They agreed that this was a liquidated damages provision. It includes some damages that we believe are hard to prove. Like, basically what we're saying is at the time of the contract, Mr. Burdett had no idea if Mr. Riahi was going to delay the performance, or how long he was going to delay the performance, or really what specific damages that would cause. I mean, if he had to have that sign to try to open another store, if it's a 1 month delay, if it's a year delay, this was an amount that the parties determined between them was reasonable, and they agreed to it. And, this case is not just about the leverage and power that Mr. Burdett had. Mr. Burdett felt that he had no other option. He had a party that was essentially saying, I'm not going to honor the settlement we just negotiated, and you're going to have to sue me to get what I agreed to give you.
So is the fact that the $10,000 equals the value of the 3 signs and canopy, is that just coincidental?
I think that I'm not exactly sure. I mean, I think that there was some discussion in the testimony at trial about, I think Mr. Riahi testified, frankly, that he had suggested that number, and perhaps that it was because he was going to also offer to return these signs. Is that an exact value? Was that negotiated when the settlement agreement was being negotiated? I don't think so. And, I don't think that it's an exact value on these signs, even though it's possibly close. So, I mean, and frankly, if each of the signs is worth the different signs approximately $3,000, and then there's also this canopy that I don't believe there was really testimony about what that was worth. So I don't know if that's exactly answers the question, but
Okay, and you're out of your time now. Does the panel have any other questions?
I have a quick question. Mr. Donnelly, did you seek actual damages in addition to the liquidated damages, or just liquidated damages?
We did seek actual damages, Your Honor, at the trial court. And I believe that the judge's ruling on that was that they were not specific enough, as I had mentioned earlier. I don't think the judge ever made a decision about the credibility of that damages number, just that it wasn't exact enough.
Do you recall what that amount was that you were seeking?
Sure. And the amount that Mr. Burdett testified, he testified that the old sign that was eventually delivered was probably worth about $3,000. And so the calculation was he paid between about $3,796 and $5,000 for the sign. So he said about half of what he paid the Lone Star was likely for the manufacturer and install of the new sign.
All right.
If we discount that by the sign that was eventually delivered, $3,000, you come up with damages between about $800 and $2,000.
Thank you.
Any other questions from the panel? Okay, well, thank you very much. We'll take this matter under advisement and get an opinion out as quickly as possible. We appreciate your arguments. This is very well argued and brief.